requesting the phone, right?
Right.
And that you provide the phone, correct?
Yes.
At the request of the AG's office? Is that right?
Right.
Did law enforcement ever contact you and ask for this device?
No, they didn't.
So the attorney for the Ellis family was the conduit for the AG's office to get you this information?
I don't know.
Well, that's what 2536 suggests, isn't it?
Yeah, he was the one that asked me.
And when there were requests that you provide interviews to law enforcement, Mr. Bible was present with you for those interviews as well, right?
With who?
With you,
No, with who were the interviews with?
with law enforcement,
State Patrol?
State Patrol.
Yes. I requested. I wanted somebody to be with me. I didn't want to be alone.
If we could bring back up Exhibit 20. Remember Ms. Eakes was having you describe what you were seeing there?
Right.
I want to keep playing.
Okay. Mm-hmm.
Well, I want the zoomed in version. So. All right. Can you see it on your screen?
Mm-hmm.
Actually, why don't you stand up so I want you to see what I'm pointing at and you can tell me what we're seeing.
Okay.
Sorry, I gotta get next to yours, okay?
Yeah.
Wait, you rewind. Don't hit play yet, please. That's the driver of the patrol vehicle, isn't it?
I don't know.
You don't know?
Sorry, I can't see where you pointed.
The individual with his back to us, right in the center, is the driver of the patrol vehicle, isn't it?
I don't know yet. If we play the video, I can play.
Oh, we're going to in a second. And you see another officer right here engaged with Mr. Ellis, right?
Right.
Go ahead and hit play. Pause it, please. Did you see one officer go back in front of the patrol vehicle?
Yes.
Okay. Did you see Mr. Ellis's legs kicking towards that direction?
I don't remember. I don't know.
Okay, go ahead and hit play. Pause it, please.
Is this slow motion?
I don't know. Did you see the person with the taser right there?
I see this person right here. I don't know.
Did you see something in his hand when he walked up?
I don't know. You gotta ask me the questions and then play it because I'm like.
All right, I want you to watch. I want you to watch this officer come out from the front of the vehicle and check out his right hand and tell me if you see a taser in his hand. Go ahead and rewind and hit play, please.
Yeah, it looks like it.
All right, you can stop. Did you see the taser in his hand?
Looks like it.
Okay. That means that was the passenger, right?
I don't know. From what I thought, other way around, but.
I don't have any questions.
Mr. Conrad?
I don't have anything, Judge.
I have one other question, Your Honor.
Ms. Eakes, go right ahead.
Thank you. Can you just explain to the jury why in the text message you said that your daughter had the phone?
I just was confused. I didn't remember. It was my other phone that she had.
And tell us what you mean by that. I mean, how many phones did you have after the one that broke?
A couple.
A couple?
Yeah.
Okay. And did you remember exactly which phone it was?
No, not until I ended up figuring it out that my phone that I did do it was in storage.
And did you correct yourself in that text message about the fact that it was not, your daughter didn't have that phone?
Yes.
Is that what we read through on the screen?
Yes.
The messages?
Yes.
Correct. Thank you.
You have nothing else.
Nothing based on that, Judge. Thank you.
Mr. Conrad?
Nothing, Your Honor. Thank you.
Okay, Ms. McDowell, thank you. You're excused.
Thank you.
Your Honor, actually, I'm sorry, I realized I had one exhibit I forgot to offer, 151B and C, which were the two that we made when Ms. McDowell was initially on there and circled, did the red circles. So if there's an objection to admitting that, we'll need to ask her a couple of questions.
No objection.
No objection, Your Honor. But we did have a discussion yesterday about whether 151A was admitted for illustrative purposes or as substantive evidence. And so,
Well, let me ask you this. She's offering 151B and C for the moment for substantive purposes. I'm not hearing anybody say illustrative. Do you object to that?
No objection.
Okay, so 151B and C will be admitted. As for 151A, I thought that was admitted earlier. And my notes could be wrong about this, but I thought it was admitted, I did not note that it was for illustrative purposes. Mrs. Winnie does not either. Has anybody else noted it was for illustrative purposes only?
I recall that, Judge, but I could be wrong.
Okay. Is there an objection that it should be admitted for illustrative purposes only now?
No, I only noted that because that's what I believe happened yesterday.
Okay, but you don't have any objection for being admitted for substantive purposes. Mr. Conrad, any additional comment about that?
Your Honor, I just wanted some consistency on it.
What's the old saying? The pursuit of a foolish consistency is the hobgoblin of small minds. I think that's how it goes. Anyway, so 151 is admitted if there was any issue about it. B and C are as well. And was there 151A that was separate from that? Okay. And that's already been admitted. Was that that was also for substantive purposes, right? Okay. That's my recollection too. I think we're all on the same page. For the moment.
Exactly. Yeah, now, excuse Ms. McDowell.
I think now you're free to go. Thank you, Ms. McDowell.
Thank you.
Can I retrieve the exhibits? I think I left some exhibits.
Sure, go ahead and check. Did we need to take something up outside the presence of the jury before this next witness testifies? Okay. So, ladies and gentlemen, we'll excuse you for a few minutes while we have this conversation and go from there. Everybody can be seated, I think. Okay, Mr. Liu, who you said was an audio guy? Who's your next witness?
Correct, Your Honor. State will be calling David Hallamore, forensic audio expert, next. The subject of a motion eliminated where the court indicated that he prepared a transcript of the various sources in this case, and the court indicated that the defense will review Exhibit 18, which is his transcript, and bring any discrepancies to the state's attention, and we would meet and confer. And if the parties still disagreed or can't agree on the transcript, then the court will listen and decide. We've let defense know for some time now that we do plan on calling Mr. Hallamore this week. They just now informed us that they do have an issue with the transcript. And so this is a matter that we need to discuss.
Can I have a copy of the transcript? Exhibit 18, you said?
Correct, Your Honor.
You would, looks like Mr. Lou's got it for us. And do I have something that says where the defense has an objection? Because I'm assuming you don't object for every line. And it is the objection having to do with what is claimed to be said, or is it an objection to a description of something like the word scream or screaming?
Both issues, Judge.
Okay.
So
So where, do I have a copy of where the defense has concerns?
I can certainly let the court know that I have concerns about the whole thing. I mean, and I've raised it,
Well, I can tell you that ship sailed, that's coming in some way or another.
okay, well, I have concerns about a number of the statements that are made in there because I've looked at his prior drafts of this transcript, and he's completely, I mean, he's guessing at a number of the I can't breathes. He's indicated in communications with the state that he doesn't have a high degree of confidence in what was said, and he's highlighted those passages as well. And then he also has continued to indicate through these communications that if they can reach a consensus amongst the Attorney General's office, then he will include it. He says, it might be tough to find consensus on the recording, but if the majority folks in your office here can't breathe, I'll include it in the final transcript. And then he goes on and leaves out certain portions. So just under the rule of completeness, he hasn't included all the things that have been said within certain portions of audio. They've only selected certain portions that they like, leaving out. So in his original draft, which he's using enhanced copies of the recordings, and he's only indicated in there, I believe it's one time where he has confidence in what's being said in terms of can't breathe, sir, can't breathe. And the other ones are specifically highlighted with question marks after them. And so, it's through these communications, and then he has communications with Mr. Liu, and Mr. Liu is encouraging him and saying, can you take another look at these and listen to them again? I hear I can't breathe at these specific time frames. And then eventually, over time, those make it into the transcript, of course. So I'm happy to voir dire the expert, well, so-called expert in his critical listening abilities in front of the judge to make this point even more clear, but it's speculation, and it's done under the guise of an expert testimony, but that's not what it is. It's a guess that's been encouraged by the Attorney General's office.
Well, I've heard some of this before. At the time this motion was discussed. In fact, I think I heard all this before. That's why I wanted you guys to discuss it. But I guess there is, at least there's one thing that occurs to me just looking at this. And as you know, this is the first time I've seen any of this. On page 2 of 6. At the top there where it says taser fired, I think it's the second line. We're all tracking the same location.
Yes, Your Honor.
Isn't this somewhere in this part of it where Mr. Osler says, try it again, or something like that. Isn't that, yeah, I'm not seeing anything like that here.
Well, and funny enough,
Where is it? Where am I?
Read down further to 23, 22, 27. On the same page.
Try again.
Yes.
the other thing I'll indicate is,
That's 25 seconds after the taser was fired?
That's correct.
Before the second.
Is that,
Before the second.
is that the defense, an agreement as to the timing? I'm looking at you, Mr. Osler, because you're my,
Sorry,
you're my try again.
Well, not my witness, so I was gonna let Mr. Arbenz deal with that, but,
Well, I'm asking about this try it again business.
well, I think it should be clear from the video, was after the first taser application, at least according to Mr. Fredericks, when he said.
Well, and this is, on the transcript, it is after the first taser's fired, but it's 2 seconds before the next one's fired, it looks like, and 25 seconds after the first one was fired. And, you know, my impression at the moment is that it was more contemporaneous with the first shot than 25 seconds. Now, I could be wrong, of course, because you guys have analyzed this to death and sliced and diced it, and I haven't, but
Consistent with what I saw in the videos, the court's impression, so. But
that it was faster than 25 seconds later.
apparently Mr. Hallimore's gonna say it's 25 seconds later.
And the other part of that, Your Honor, as indicated, my recollection of listening to this a few times this last 24 hours, is that with the try again, she's actually driving right next to them. Where they have it here, she's still behind the car, police car. That's taken out of context.
No, Judge, I disagree. On the video, Ms. McDowell's not even in the scene, and she comes after that, so.
Yeah, that's my understanding as well.
Your Honor, the timing of it is something that Mr. Alamo worked with Grant Fredericks on. I would imagine that they would be more accurate instead of their collective memories of what they recall.
Well, it's my selective memory that I'm drawing on them. They're not the ones that's saying the try it again business. And of course, this is try again, and there's a dispute about whether it's try again or try it again. Makes a difference, I think. My own, you know, my own take on it was, even though Mr. Fredericks couldn't discern anything, it sounded like try it again to me, but you know, everybody can hear things differently.
Well, interestingly, Judge, Mr. Fredericks in front of the jury suggested he didn't know what they were saying. Now we're hearing he worked with Mr. Hallimore with the transcript, where he says it in the transcript.
You did say that. I don't know about the working part.
They work together at the same time.
Well, but he would have to know what was said to place it on the timing, right? So where are you gonna put this remark? At what point? So wouldn't he have had to work with him about that? Which would mean the substance of the conversation, Mr. Liu. What am I missing?
What Mr. Hallimore will explain is that he listened to the different sources, from the Vivint, from the dispatch calls, from Ms. McDowell's videos, and then he, from those different sources, he worked on the timing of it with Mr. Fredericks to put together the same time.
Because as we heard from Mr. Fredericks, he had to do a little adjustment to sync the times up
Right.
with all these sources. And he explained in some detail why he did that and how he did that.
Right.
But are you saying that Mr. Hallimore had his own source for some of this?
No, the transcribing of it, he listened to the different sources himself, but in terms of the timing, then Mr. Hallimore then worked with Mr. Fredericks to determine the timing of what was said.
Well, as I say, does the defense have their own write-up of what this should read? Because I haven't seen that. I don't, right now, I'm only guessing as to what you think is wrong about this.
well, just for the court's information, I'm looking at an email where Grant Fredericks, it's actually from David Hallamore to Grant Fredericks with the transcript. So to state that they just worked on the timing of it and that Grant Fredericks wasn't aware of what Dave Hallamore's transcript was, or what, you know, what he's saying was heard in it, is just not true.
Well, it sounds like Mr. Fredericks is coming back and you'll get your chance, but you didn't answer my question.
Sure. Do we have a copy of what we think the appropriate transcript should be?
Yeah.
We can certainly get that to the court. But
So the answer is no.
the answer is no, but I can tell you the issues that I have with what's included in this, which is what the court's already, I think the first point by the court is spot on, which is this screaming versus yelling. And they're now indicating it's screaming, again, through communications with the AG. That's what they want the jury to hear. But he doesn't have any ability to listen to this audio and make a determination any more than you or I, Judge, or the jury. He can enhance it and tell the jury he's enhanced it and then play it for the jury so that they can listen to it. But to go beyond that, I think, is he hasn't testified, and he won't testify that he has some special ability to hear what Mr. Ellis says, or that he's familiar with what Mr. Ellis's voice sounds like, or what all the other witnesses' voices sound like. And that, I mean, when you look at the case law and you look at when an expert or an officer, for that matter, can testify about who a particular person is in a video, or what a particular voice says, or who it belongs to, it's because they have some familiarity with those people in order to provide the jury with an opportunity to know that information, and because they've had an opportunity to converse with the person or seen them walk before. And that just isn't...
That kind of thing is usually required if it's sort of out of context, like I'm hearing a voice on the phone, I recognize this as Joe Blow's voice. Well, how do you do that if you're simply the records custodian for the jail? Because you don't know this person, right? So there's always, usually the state's got to lie some foundation that I'm familiar with the voice, that's the voice, and then the rest of it's weight, not admissibility. Here we have a video that is linked up to various sources at certain points in time. I mean, I don't know that there's a whole lot of dispute about what Ms. McDowell said to Kenyon, for instance, and that it was her saying it. We can pretty much tell from that video, right? Now, there may be other points in which this is obscure as to what the source of the sound is. And what's a scream versus yelling? Versus, so I got scream, screaming, crosstalk, unintelligible, unintelligible yelling.
Things that Mr. Albert will explain, sort of this process of indicating whether it's intelligible or unintelligible speech. And he'll explain, based on his expertise and experience in doing this, how he determines what is considered. Your Honor, this is for illustrative purposes as a listening aid to the jury, and ultimately it's up to the jury to decide what they hear. But we think it would be helpful for the jury to have this transcript.
Well, it's true, we wouldn't ordinarily let this go back to the jury room, but it needs to be accurate in the first place, because they're going to potentially have an impression of it just from what was read on here as opposed to what they hear on it. So it has to be neutral. I know there was some controversy about what was the description of Mr. Ellis's sounds. At one point, there was a somebody described it as an animalistic sound, and the state complained about that. And I said, well, I'm not gonna edit anybody. If that's how they think it sounded like, then that's what they think it sounded like. So, and I think we've already had some kind of an issue during the examination of Mr. Fredericks about a particular noise that appeared to emanate from Mr. Ellis as to what that was. And then, and then there was an argument about what the descriptor should be. So even that kind of stuff is not agreed to.
The animalistic noises, I mean, those are descriptions coming from witnesses who were actually present on scene.
No, I understand that.
Okay.
But you may remember, and I'm sure you do, the state wanted me as a motion in limine to not let that come in. And I said, I'm not going to tell the witnesses what they can say or not say. If that's what they say, that's what they say. If they say something different, that's fine too, but it's their testimony. It's not for me to somehow sanitize it.
That's correct, Your Honor, but that's not part of the transcript.
No, I understand that, but I don't know whether this has got the same thing or not. I don't know. Because as I understand it, at least some of those noises that we're talking about came after medical aid came, right? Or at least when other police officers were there, which is before all this. Well, I guess it's not entirely before all this, because some of this has to, at the very end, it has to do with getting the ambulance there, so other officers are there. And it ends at a point where it says, fire's advising they're pulling up on scene. Was that the end of the dispatch recording?
Correct. Mr. Howell will provide the transcription until fire is pulling up to the scene.
Right, was there some reason he stopped there? Is that where the,
Relevant portion of it. Otherwise, it'd be a very long transcript.
okay, there was other, the dispatch audio continues beyond this period of time. Well, when is the defense going to give me their version of this?
We can work on that right now, Judge.
How long is it going to take?
I would have to. I mean, the problem is that, again, I don't think the state and the defense are going to come to any sort of agreement as to what's being said in some of these things.
Oh, that may be, but I want to reinvent the wheel. If you guys agree on nine things out of 100, at least there's 9 things I don't have to decide,
Sure.
right? So
We don't intend.
I'm imagining there are some things you don't disagree about.
There might be, but I guess from our perspective is, we're not offering a witness or an expert to try and tell these jurors what they should or should not hear in the audio.
Well, that is of little a moment to me, Mr. Conrad. I've got a witness that's being offered from the state to do this. This kind of thing has happened in other cases. This is not brand new. Often it's a recording of somebody's statement to the police as opposed to this kind of thing, but still, we do what I've done here, which is you guys have the recording of it too. You can listen to the audio. You can say where you think it's wrong, because if you don't tell me where you think it's wrong, then I have to assume this is right and we're going to play it and give this to the jury. If you guys tell me where you think it's wrong, I may well agree with you and take some of this out or change the description. So instead of screaming or unintelligible yelling, I might just say loud noise, loud, unintelligible, or loud voice, unintelligible. At least describe it as a human as opposed to an inanimate object like a car horn or a screech of a brake or the tone that might come across the radio because of the police information, which isn't necessarily a voice. So, I mean, those kinds of things. So if we're talking about loud human voices, fine. There's also an indication here of things that are not on the audio, like taser fired, unless you can hear it. Can you hear it? Okay. I know you can see it, or at least some aspects of it. So if that's part of the audio, of course, then that's fine. I don't necessarily have a problem with putting a taser fired in here, even if you couldn't hear it, to be honest with you.
The problem is the court did direct the defense to review.
Right, but you can see how much trouble I'm already getting, even when I ask directly, Mr. Lowe.
And provide any objections and we can.
So when did you give this to the defense?
They've had it for a while now. It's been quite some time.
And I've been raising issues with it the entire time with the state, saying he's guessing at these instances. So if the court wants
Well,
to
right,
take
you told me about that thing with Mr. Lowe and stuff.
sure. So
I don't know whether there's been any improvement about that.
if we can take a break, then I will remove the instances that I think should be removed because it's speculation, and I can provide that to the court.
Okay.
I don't
Is
think
this-
it will take
this-
me
is
very
this
long.
Is this based only on what Mr. Liu's opinion was at some point in time, or your own independent listening to this?
No, this is based on what I'm reviewing, which are the communications from Mr. Hallamore, where he's indicating I can't be certain about these
Right,
these
but-
statements.
But if he says the word that they said, Ms. McDowell said, just arrest him, and you think that didn't happen, then I need to know what you think he said. Or if Mr. Liu at some point says, I think what she says there is just arrest him, and Mr. Hallamore couldn't tell that himself, but you agree with Mr. Liu, then why am I taking this out if everybody agrees that it is one way and Mr. Hallamore thinks it's something else? And I don't know which way this is going to cut. So here's my question to you, Mr. Liu. Have you got another witness handy by?
We don't.
I can check to make sure he's still here. I told him that he wasn't gonna be on until 3 because we were running late, but I did.
You're talking about Mr. Hallamore now?
I thought you said we have another witness.
I'm asking you, do you have another witness? And you said he, but I don't know who,
I had a
who,
witness lined up.
who is that?
And Mr. Atzett.
Mr.,
He's the Pierce County Medical Examiner Investigator.
okay.
So
So why don't,
I just need to make sure he's still involved.
please do so, Mr. Nicolavo, and if he's available, we'll call him instead. And in the meantime, you guys sort this thing out. I want to know first thing in the morning.
Yes, Judge. Well, Your Honor, Mr. Hallamore is from out of state, and we do plan on putting another witness on tomorrow. Again, the defense have had plenty of opportunity.
Well, is Mr. Hallamore got airplane tickets to leave here tonight?
Yes.
Well, ask him to change them. I'm sorry, but, I want to get this right the first time.
Your Honor, he is here. I have several exhibits I need to get prepared before the jurors come, but he is in the hallway and ready to go.
All right, well, the Fair Labor Standards Act say I have to give my staff a break of 15 minutes during the afternoon, and so we'll do that now while you can organize those. I don't mind if you guys work yourselves to death, just as long as my staff doesn't, because I don't get sued if the lawyers have problems. I only get sued if my staff gets problems. So we'll take our 15-minute recess, let the jurors know that too, and then hopefully we'll be ready to go in 15 minutes with all that. And thank you very much for accommodating that. Appreciate it. ready for the jury then, everybody?
Yep.
Let's have the jury. Thank you. All right, welcome back, everyone. Please be seated. Okay, Mr. Calavo, your next witness, please.
Thank you. The state calls Pierce County Medical Examiner Investigator Jacob Atzett.
Yes, sir, please come forward right about here. And right over here, and then raise your right hand to be sworn. Solemnly swear or affirm that your testimony in this cause will be the truth, the whole truth, and nothing but the truth. Thank you very much, sir. Have a seat right here. Please state your name and please spell your name.
My name is Jacob Atzett. Jacob common spelling, Atzett, A Adam, T Tom, Z zebra, E Edward, T Tom.
Your witness.
Mr. Atzett, we spoke earlier that I thought you had this soft voice, so you might need the lapel mic, but it sounds like you're just fine with the mic. If that changes, let us know, and we've got one right there to use.
Okay.
Can you please tell us what your current occupation is?
I work as a medical legal death investigator for Pierce County.
And how long have you been so employed?
At Pierce County since 2016.
And what positions have you held at Pierce County?
In 2016, I was hired on as a autopsy technician, and then in 2018, I was promoted to a medical legal death investigator, and I've worked that way since.
And can you tell us first what an autopsy technician does?
Assist the pathologist during examinations, primarily.
And when you refer to pathologist, are you referencing the medical examiner who actually does the autopsy?
Yes, the medical examiner performs the autopsy, yeah.
And what are your duties as an investigator?
To determine jurisdiction in reports of death and collect evidence to provide to the pathologist.
Do you also include, when you're collecting the evidence, does it include processing a scene for the evidence?
Absolutely, yes.
Can you tell us a little bit about background on what that includes?
We coordinate with law enforcement. Usually we're notified by our local dispatch agency, South Sound 911. That's when we begin investigating the case to determine jurisdiction. But we communicate with law enforcement on scene and respond to the scene accordingly. We document using photographs, notes, and obtain any physical evidence at the scene that may be relevant. And then we also perform a external examination of the body at the scene, and then transport the body back to the medical examiner's office for further examination.
And with that, you said that you speak with law enforcement on getting background from them of what occurred.
Yes.
And